Hey everyone, welcome to our Facebook Live event. My name is Sarah Durham. I'm one of the post-conviction attorneys here at Blizzard and Zimmerman. Here today to answer the questions that you guys write into us on the regular about direct appeals and 1107s, 1107-2s, the writs of habeas corpus, and just share with you our experiences and what we know and try to answer your questions the best we can. So let's dive in. We've got a couple of questions from, I believe these were from last week. One is just kind of a really general question. What does post-conviction relief mean? And so just to break that down really simply, post means after, right? And conviction is when you were convicted. So when the judge pronounced your sentence at trial, you were considered convicted. Even in the post-conviction sense, even when you sign or when the judge signs your order of deferred adjudication or your order of community supervision, that is considered a conviction for post-conviction relief purposes. We won't get into all the other ways that it's not really conviction, but sometimes it is a conviction. In order to challenge it, once that judge signs the order of deferred adjudication or the order of straight probation or community supervision, that is considered a conviction that you can then challenge through, in that case, an 1107-2. Otherwise, once the judge pronounces your sentence at trial, they sign the judgment, then you have, we've talked about these before, your timelines, 30 days to file that notice of appeal. Once you're all the way through that appeal process, then you can file an 1107 writ of habeas corpus to challenge a felony conviction. Remember, those are only for felony convictions. If you're talking about misdemeanor convictions, you're talking about an 1109 writ of habeas corpus. I encourage you guys, those of you that are thinking about hiring an attorney or doing it on your own as far as filing a writ of habeas corpus, that number 1107 comes from the article in the Code of Criminal Procedure. So you can just go to Google and Google 1107 Code of Criminal Procedure or Article 1107, and then it plus all the other ones associated with it will pop up for you, and you can read the statutes there. And then, as we've talked about before, Google Scholar will also allow you to look up cases that talk about those statutes. So you can kind of see how the courts talk about them and how they're treated among the different Texas courts. Let's see. We were also asked in relation to that question, is it too late to do anything after conviction and sentencing? And just like we talked about, that's when post-conviction relief happens, right? So those of us at our firm that do post-conviction relief, we're only doing things that happen after conviction. So we're not really part of the trial process or the pre-trial process. It's about once you are convicted, then what do you do? So it's definitely not too late to do anything. You either file a direct appeal or you file an 1107. And I present those as an either or. It's best to file the direct appeal first because the 1107 and timelines associated with that start after that direct appeal is final. Okay. What's the difference between an appeal and a writ of habeas corpus? So a direct appeal, again, that is what happens directly after conviction. You've got 30 days to file that notice of appeal, unless, those of you who've watched before know what I'm about to say, unless there was a motion for new trial filed that extends your timeline to file your notice of appeal to 90 days, right? So 30 days of no motion for new trial, 90 days if you filed a motion for new trial. Then you go through the direct appeal process, you file the appellant's brief, the state responds, then you get the answer or the opinion from the Court of Appeals, right? There's 15 intermediate courts of appeals in Texas, and that's who you are arguing to, depending on what part of the state you are in. So they make that decision, file their opinion or submit their opinion, either granting or denying your appeal. If it's denied, you have another timeline to think about. You have 30 days to file a petition for discretionary review to not the intermediate court, but the Court of Criminal Appeals of Texas. So that's the highest criminal court in Texas. They're on par with the Texas Supreme Court, but Texas Supreme Court handles those civil cases, the CCA handles the criminal cases, and that's who your petition for discretionary review goes to. There are also extensions you can file as far as, filing an extension to file your notice of appeal or your petition for discretionary review. We won't really get into those. Just know that 30 days is a really good, kind of rule of thumb. Once your appeal is denied, you have 30 days to file that PDR in the CCA. Now, if the Court of Criminal Appeals grants your PDR, then you have 30 days to file a brief in the Court of Criminal Appeals. They'll give you a briefing date. If that is refused, if they deny your PDR, or if your petition that you are allowed to file is eventually refused by the Court of Criminal Appeals, that starts a new timeline, okay? And we're still in the direct appeal phase, folks. The notice of appeal, the PDR, and then if that's refused, you can file a petition for writ of certiorari with the Supreme Court of the United States. Not a lot of people do that because A, it's super difficult, time-consuming, very expensive. And I mean, if you've followed the Supreme Court about anything, usually those kinds of cases that the Supreme Court grants petition on to look at and review and ultimately decide are usually either novel issues that have kind of like just come up. Think, we're encroaching in this time of AI, so probably some cases surrounding AI and how that's handled, in various ways will probably find its way to the Supreme Court. Otherwise, it's just really those hot button issues, right? Having to do with equal rights and things of that nature. So if you're appealing from, a felony drug conviction, you're probably not going to get your petition for writ of certiorari granted with the Supreme Court of the United States. But that doesn't mean you can't try. So after that PDR is refused, you have 90 days to file the petition for writ of cert with the Supreme Court of the United States. If you don't do that, that 90 days becomes part of your direct appeal timeline. At the end of that 90 days, your direct appeal, starting with that notice of appeal, is now final, done, right? And that's when you file the 1107 for writ of habeas corpus. Now, the 1107, there's really no timeline associated with that. So after that direct appeal is final, maybe it's 2 years down the road, and you want to file an 1107. You can do that. So just know that the direct appeal happens first. The 1107 happens afterward. And then one other main difference, and again, you guys have heard me talk about this, those of you that tune in and have followed us on Facebook and things, another big difference of direct appeal and the writ of habeas corpus is that on direct appeal, you're really relegated to the record, right? The transcript, the trial transcript. So what was said at trial, you're arguing the trial court abused its discretion. You're arguing that, anything that, where the trial court abused its discretion for admitting evidence it shouldn't have or excluding evidence it shouldn't have. You can do a certain amount of constitutional challenges on direct appeal, not so much. You can challenge the sufficiency of the evidence on direct appeal. And then, so your arguments are rather limited. You can challenge the jury charge, you can challenge what happened in voir dire, but ultimately, again, if it didn't happen at trial, it's off limits. So if it's something like an outside witness were to testify to, or additional evidence were discovered, all of those kinds of extraneous things that happen outside that trial, if you wanted to argue, if you wanted to get them before a court, has to be done through an 1107. Right? So direct appeal, transcript only, 1107, transcript plus really anything else. Okay, so you have a lot more freedom in an 1107. But you're also, in an 1107, we tell clients this all the time, the further you are removed from that conviction, right, each step you take to challenge that conviction becomes more and more difficult. So just keep that in mind too. Let's see. All right, we have some questions about who can file an 1107. This particular question, does the inmate have to file it personally? That can be done, like an inmate can file a pro se 1107. If you Google, again, 1107 application form, it will pull up the 2018 form that's issued, that the Court of Criminal Appeals has on their website. And you'll see in it that, I think page 18 or somewhere around there, there's an oath for the inmate. So if they fill out the application pro se, meaning on their own, they can sign it, right? On their own. It doesn't have to be notarized if they're an inmate signing their petition. Otherwise, if it's an attorney that prepares the 1107, or even a family friend or a family member that prepares the 1107, I have a place to sign on the petition, and as would a family member or a friend. So there's 3 distinct places for someone, whoever prepares the application, to sign it. So that's good to know. So an inmate can file pro se, he can hire an attorney to file it, or an outside person can file for them. Let's see. What are common grounds for filing a writ? Hopefully, those of you that, again, watch us frequently or follow us on Facebook are already talking out there and saying what grounds we can bring in an 1107 writ, which the main one, ineffective assistance of counsel, right, where you're saying that your counsel made a mistake and that mistake caused you harm, right? That's what you're arguing in an ineffective assistance claim. New evidence. So if there was new evidence that wasn't discoverable at the time of trial, at the time maybe you pled guilty or at the time that you had your trial, you can present that new evidence in an 1107. And basically you're arguing that this new evidence, right, establishes your innocence. Okay? So we also call those actual innocence grounds. There are due process violations, and those mainly center around, you're talking about false testimony is a due process violation, prosecutorial misconduct is a due process violation. So that's typically what those kinds of violations are tied to. But goodness gracious, I'm getting a little tongue-tied. Mostly what you'll see in 1107s is ineffective assistance of counsel. And when we file those, sometimes our clients are kind of surprised to find out that, so we assert ineffective assistance, not a problem there. So we'll even reach out to that counsel to say, okay, these are the things that we found. These are the grounds that we're bringing. Would you like to respond to these? Maybe the trial counsel will, maybe he won't, or she. But ultimately, eventually, they're going to have to respond, right? The trial court, when you file the 1107 in the convicting court, if the trial counsel that you're asserting ineffectiveness against hasn't responded in any way, hasn't provided a statement or an affidavit as part of your application, the trial court will order them to do so, okay? Because a convicting court, whether, all the way up to the CCA, they are not going to find ineffective assistance without the input from trial counsel. So just keep that in mind. Trial counsel will have an opportunity to really combat what is being asserted or even agree with what's being asserted. How long does the 1107 writ process take? That is a really good question. I know we've addressed it before, but it is worth talking about and noting again that the 1107 process is not fast. The direct appeal process isn't even fast. It takes a long time to get through all that's required and for the courts to review everything that there is to review and then make their decision. But what was asked was about the 1107 process, so I'll just talk about that one. Once we are hired, I'll just use our own experiences as an example. Once we're hired, it'll take time for us to gather all the records that we need to do a full review of the trial record, and then anything that we might have to create, right? So if we need to question witnesses or we need to speak with jurors who might want to speak with us, there's a lot of things that have to happen in order for us to even kind of do a fulsome review and determine what grounds exist for the 1107. Now, we have an idea, right? Because we've already had a consult with the client and we've talked about what they think might have gone wrong at trial, the ineffectiveness of counsel. Maybe there was some false testimony provided by a witness. We follow up on that. So once we get all the records, once we do that full review and then we file, that entire process can take anywhere between 6 months to a year. Okay, depending on how quickly we get the records, depending on how quickly we can talk to the parties involved. Once it is filed, then you have a pretty distinct timeline, right? That is statutory based, so that's easy to talk about, easy to remember, right? So once we file, the state has 30 days to respond. If they don't respond, they don't have to. If they don't, all the grounds that we asserted are deemed denied by the state. Then the trial court has 20 days after that to submit what's called an order designating issues. And that is, the trial court says, there's you've elicited or you've asserted facts that if those facts are true, could entitle you to relief. So we need to talk more about this, right? And that ODI or order designating issues will say, we need affidavits from the parties involved. Maybe it's trial counsel. Maybe it's even state's counsel. We've had affidavits ordered from prosecutors as well. Or maybe we need to have an evidentiary hearing. If we're asserting that witnesses lied, then the trial court will likely want to hear from those witnesses to determine their credibility. Ask them point blank, did you lie at trial, right? And see how they react. So an evidentiary hearing can be ordered. So that puts you, if you're keeping up, that's 50 days from the date we file, 30 days for state to respond, 20 days for the trial court's ODI. If the trial court does file that ODI, then that extends the timeline. It can hold on to the writ to 180 days from the date of filing. So now you're looking at, from the date of filing, 6 months until the court has to forward everything to the Court of Criminal Appeals for final decision. So during that 6 months, right, after that 50 days, the ODI, then you've got about 4 months left of that timeline. The trial court has to order that the affidavits be submitted and or an evidentiary hearing be held. Your writ counsel and the state also have other things that they will file, proposed findings, objections. All of these things are possible during that time period, the 180 days. And so once all of that is done, right, and sometimes it exceeds the 180 days, there are extensions requested, but once it's all done, it's all forwarded to the Court of Criminal Appeals, and they don't have a timeline that they have to abide by as far as when they have to make a decision. But I will say that for the most part, they make a decision within 3 to 6 months. So that's from the date of filing to the date you get your decision. You're looking at least probably a year, okay, before you get that decision. So 9 months to a year until it's filed if you hire an attorney, or even if you do it yourself. It's a lot to gather and to review and to prepare. And then another year until decision. So you're looking at about 2 years before you get a decision once you file an 1107. Now, of course, I would say on average that's the case. There are some that get decided sooner. There are some that we have had pending for more than 2 years. So but on average, just know that it's about 2 years. One person asks, again, along those lines, can multiple writs be filed if one has already been denied? Yes, but if you've already had one that's denied, right, and denied means that it was decided on the merits, versus dismissed means it was dismissed and kind of kicked back for non-compliance, or you used the wrong form or the wrong font or something, that can be refiled as long as you fix whatever was wrong, right? So a dismissal is not a denial. So that's important to note. But if it's been denied, it means the court looked at everything and decided on the merits that this writ will be denied. So you're kind of, almost at the end of the road, right? But if new evidence arises later on, or if new legislation about your case that's associated with your case, not just some new random law, but if new law associated with your case comes up, then you can file another writ based on that new law. So an example of this, if y'all want to look it up, there's a case recently called Glossip v. Oklahoma. It's Glossip. In that case, oh my gosh, I don't even know how many writs were filed. I think 3. I think the guy had 2 new trials. He was convicted again both times, and the third time was a charm. And new evidence was discovered that the state had withheld some exculpatory evidence about one of the witnesses and his lying on the stand. So you have, think about all the things you have. You have new evidence, you have prosecutorial, misconduct, maybe some Brady violations, all of this stuff wrapped up into this case that took years and years and years to get through, and finally Mr. Glossip was granted a new trial. That one went all the way to the Supreme Court of the United States. So, and that was out of Oklahoma, so it followed a slightly different path, but just that's a good case to look at to see kind of the back and forth, and then the new evidence that can arise and what that looks like, and when you can file another writ. Also new legislation. A good example of this was the Lowe decision, which don't get me to line about when it was decided. I think it was like mid to like 2017, 2018, somewhere around there. Anyway, it decided that one of the statutes concerning online solicitation of a minor was unconstitutional. And if a statute is found unconstitutional, it's void from inception. So those that were convicted of online solicitation of a minor under that statute, even if they had already filed a writ before, could file another writ and say, whoa, this opinion from the Court of Criminal Appeals made this statute unconstitutional, therefore I'm not even really guilty of this offense that I was convicted of. And so several successive writs have been filed and granted based on that decision in Ex parte Lowe, which is LO, if you want to look that up too. Let's see. Okay, this is a really good question. I mean, we kind of already talked about it, but I can kind of talk about the pros and cons here. Do we need an attorney to file a writ, or can the inmate file it themselves? Okay, we just talked about the inmate can definitely file him or herself. They can file a pro se writ, sign the application themselves, prepare their own brief, the whole 9 yards. But hiring an attorney to file a writ, if you can't afford it, is the best route, and not just because we want people to hire us to file writs, because the attorney, and even sometimes we struggle getting records, right? You need to review discovery. You need to get a hold of trial counsel's file. All of the records involved, some of them are, very sensitive in nature. They're confidential. Sometimes we have to file motions to get a hold of them. We travel to DA's offices all over the state to review some discovery. So it's, I would say it's worth it to hire an attorney, because not only do they have access that inmates and family members and friends simply just don't have, but once they review it all, which can be a lot, they know what they're looking for, right? So it's not so overwhelming. If you cannot afford an attorney to do it for you, I just encourage you to do things like you're doing, right? Tune in to podcasts, to Facebook Lives, and do your own research on the internet and Google Scholar and things like that. Read case law, read statutes that are associated with your case, and just become really familiar. A lot of the times, we'll get inmates calling us and they know their case frontwards and backwards as far as facts go, right? Which is really helpful to us. We rely on them a lot to kind of fill us in on the facts and help us know kind of what to look for, what kind of direction we need to go in. And then as far as the law applied to those facts, that's where we come in, right? Although I will say some of our clients come in kind of recommending legislation and cases and things like that, a lot of the times they are right on about. So it's not that it can't be done, but even if you know the facts of your case and the law associated with your case, getting a hold of all those records, that discovery that is no longer available to an inmate in prison, that's really important to have. So hiring an attorney definitely has its benefits. This is a good question. We've never had this before. The difference between hiring a post-conviction attorney and a regular criminal defense lawyer. So when people ask me what I do, it's like I'm a criminal defense attorney, right? But I do appeals and post-conviction. It's like I always have to kind of qualify that, because there is a difference, right? So a regular criminal defense lawyer, I kind of like to think of as a trial attorney, right? So like Jacob Blizzard at our office is a trial attorney. He is a regular criminal defense lawyer, although he does appeals and stuff as well. But those that kind of focus on trials, right? Pre-trial and trials, those are your defense lawyers. A post-conviction attorney or an appellate attorney are those that focus on those direct appeals and post-conviction. So while we participate in some trials, even maybe handle a couple of trials of our own, the bulk of our practice is appeals, right? So we're looking at the trial that has already happened to find the mistakes that happened, right? To argue on appeal or in a writ. So that's your main difference of post-conviction attorneys and a regular criminal defense lawyer. Let's see. Here's one that's specific to our firm. How does Blizzard and Zimmerman approach post-conviction cases? I've kind of already touched on that. When we are hired, we, of course, have everybody sign the proper paperwork and all that, but then we reach out to trial counsel, we reach out to appellate counsel, to the state, and determine how all of those people want to share their records with us. So sometimes the state will just give us access to discovery through a portal. Sometimes we have to file a skeletal writ. Sometimes we have to go in person and review the discovery, and we're not able to access it online. Trial counsel, sometimes it's 10 years down the road when we're trying to challenge this thing via 1107, and they've already destroyed their records. So we know that we're not really going to get anything from them other than what they've already shared with the client and what has kind of survived from what the client's been given over the years. And then once we get all of those records and we're satisfied with our record gathering, we review, right? And that is we really do go through all of the records, and we have team meetings, and we discuss what we found, and we discuss potential grounds, especially, we go back to our consult notes, right? What have we thought was wrong with this case from the get-go versus what we're now seeing once we review the whole record? Do those things match up? And then once we determine what grounds we're going to bring, we start the writing process, which is the preparing the application and the brief that goes with the application. And then we file those, and then again, the timeline that I talked about earlier, 30 days, the state has to reply, the trial court has to file its ODI, and then we do proposed findings, we can file objections. So once we file the writ, we follow it through to decision from the CCA, and sometimes even then, we'll file a request for reconsideration to the CCA if we're not happy with their decision. But then ultimately, once we get kind of that final denial from an 1107, that's where it ends, right? Unless our client wants to file a 2254, which I'm not even going to talk about right now because that gets a little more complicated. But that is the process, right? And you can kind of see why it would take so long to do, right? Because that's one of those advantages of hiring an attorney, because we do kind of turn over every stone. I can't tell you the number of times that what we've discussed in a consult, yes, might be something we argue, but then we find something else, right, in our review that our client didn't even think to look for or didn't know existed, right? So another advantage to hiring an attorney. Okay, we just got a question from Rebecca, who asks, what do you do if you have already hired an attorney for your first appeal and feel like they are not helping? I caution everyone against thinking your appellate attorney's not helping. And I say this for, a really, again, out of experience, because once you hire that appellate attorney or the appellate attorney is appointed, right, there is a rule that says we have to contact our client within, I think it's like within a business day, 24 hours, and tell them, look, I'm your attorney, I'm going to request records on your behalf, and I will be preparing your brief. Right? That's basically all you have to communicate with a client on direct appeal. Okay, now a lot of the times, especially at our firm, we'll talk with our clients more. We want to hear about the trial. We want to kind of know what they're worried about, explain the process to them, explain the timelines, and keep them updated. Although not every attorney is going to feel that way, especially, it just depends on the situation. But just know that after that initial, hey, I'm your attorney, I'm going to be filing a brief on your behalf after I gather your records, that's really all that's required. Then, once the brief is filed, right, in the Court of Appeals, whichever one that may be, then the brief, a copy of that is given to the client, right? And then the state files their answer to that, or their response to the brief, and then your attorney can file a reply or not, doesn't have to file a reply, and then the court makes its decision. But again, as aforementioned, because the direct appeal is based only on the transcripts, right? What happened or didn't happen at trial, the errors that occurred on the record, those are the things we're looking for. Those are the things that we're arguing. So it doesn't require input from our client like an 1107 does, right? When you have the kind of just the whole universe available to you. Direct appeal, we're stuck to that transcript. So it really doesn't do just a whole lot of good to talk with our client. Also, a lot of people don't know about this website, and I think I've shared it with y'all, but let me share it again. It's texcourts.gov, and that is TXCOURTS.gov. And on that website, there is a place you click on courts, and really can click on any court, but if you know which court, let's say we file a lot in let's just do Court of Criminal Appeals. That's that highest criminal court in Texas. And there's a place under case information called case search. Click on case search, type your loved one's last name where it says style, and then you get a whole list of everybody with that last name. I mean, you can include, if you know the case number, you can include it. It'll narrow down the search. You'll see when you get there that you can include a lot of different information. But once you get there, it will show you when that brief is due. It will show you when the notice of appeal was filed, when the clerk's record was filed, when the reporter's record was filed. Really, anything that's going on in your direct appeal case is reflected on that page. So your appellate attorney, you might feel like they're not, always easily accessible or whatever. It's probably because they're in their office writing a lot of briefs. And that's very time consuming. So that page, texascourts.gov, will give you access to what is happening in the case. Once the brief is filed, as long as it doesn't have confidential information, you can access that brief and read it on Texas courts. When the state files their brief, you can access it. And then ultimately, when the opinion is issued by the Court of Appeals, you can access it. So that's a really good place to go to keep up with timelines. And, I've had, clients go and be like, hey, the brief was due 2 weeks ago. What's going on? And so that's good information to know, right? That's when you do want to reach out to that appellate counsel and be like, hey, brief was due. What's going on? Why hasn't it been filed? That's when you do need communication. Otherwise, if things are, kind of going as they should, just kind of let the appellate attorney do what they do. Let's see. I think, are we out of time, Tom?
Yep.
Okay, awesome. Well, it was good to be with you guys, and I will see you next time on the next Facebook Live. Get your questions in, and we will talk about them then. Have a good one.